What's up, everybody? Welcome to our little webinar that we're going to be doing. I'm going to bring on the co-presenter. His name's Dan Shapiro. Dan, thank you for coming on. It's an
my pleasure, Tom. Thank you for having me.
Well, it's very important, one, because a lot of people are upset, and this is about not just the dispensaries. We can also touch on issues and theories in cases that would apply to the Department of Agriculture sent out a wave of disqualifications on Tuesday, August 17th. So we can also kind of talk about those a little bit. Before we get going, why don't you introduce yourself? I'll share my screen so that we can do the presentation.
Great. Thanks, Tom. And thank you for all of you who are listening and watching. My name is Dan Shapiro. I have my own firm in Northbrook, Illinois, which is about 25 miles north of the city of Chicago. I've had this since the beginning of 2015. Before that, I was in Big Law downtown, and I had a various different levels of experience working for medium, small, and large firms.
Awesome.
My firm concentrates a lot on land use and zoning, as well as the cannabis space. And with that, Illinois is just starting to get going again after a long pause of about a year and a half for reasons that I'm sure many of you already know.
That's right. That's right. And so one of the things I'm saying, my name again, Tom Howard. My firm is called Collateral Base. We're really excited about New Mexico and New Jersey right now. It's hot out there. And so we first need to make sure that everybody who applied in Illinois gets their due process rights heard. 1 in 5 billion shot they got it right. After I've done some of the math, you're going to learn some math today. And Dan and I will be trading off and discussing the types of claims that your teams can advance in courts of law. There we go. And so at the end of this, we'll take some questions, and we're going to do an outline of the litigation, and we're covering, again, both the IDPFR, that's your dispose, and then your IDOA, that would be mostly your craft grow or your infuser. If you missed on your transporter application, I would never recommend anybody sue on that right now, in the sense that it's August 31st and it's an annual license. And it's an unlimited annual license. So you'll get another shot at that. Okay. So you didn't win, or you're one of our peers that practices in this area and is watching our thoughts on it. And that's cool. In this, we're going to cover the deadlines for filing the lawsuit. We're going to have some examples of cases that have been brought in federal and or state court, because the WA case, which is now the Hay case because WA dropped out, was filed in state court. We're going to go over some math regarding the third lottery in particular, and request for relief and examples, because that's what you do in lawsuits. You request relief. And so there's that. Dan, why don't you discuss some of the headlines? not the headlines, the deadlines that are out there that we have to comply with.
Sure. So just going back on the request for relief, there's no such thing as a just cause. So we can't file a lawsuit just because we're upset, or just because we lost, or just because we want to feel better about ourselves for filing a lawsuit. We have to have a reason. But before we even get to the reason, we have to understand what our deadlines are. To file a lawsuit for any viable claim that you may have with the judge and the court, we have to do so within 35 days of your denial. So that's would be a complaint for administrative review. That's a hard statute of limitations. If we don't meet that statute of limitations, we are not SOL, statute of limitations, we're SOL in a different way. So that's something we all have to make sure there's not a lot of time between the time of the denials and that deadline. So we have to think about fact gathering, putting a complaint together, working with clients or one another to get it right.
Right. And so let's go over exactly when that administrative review period starts. We have this is that August 6th, 2021 letter that everybody who's watching, who's on the dispo end, is probably intimately aware of. We also know that what has happened is that there was this termination of the abandonment period that expired on Thursday, August 26, 2021. Here we are on Tuesday, the 31st. I have not checked the IDPFR's website today, but perhaps today, maybe tomorrow, keep checking that website. You're going to have this paragraphs, the end of it right there, the end of it. Promptly after the final lottery, and then they say the tied applicant lottery and its corresponding abandonment period, the department will post the final list of applicants that may be eligible to receive a conditional license. The posting of that shall serve as the defendant's final administrative decision for all licenses awarded in each of the 3 lotteries for the purpose of judicial review pursuant to 410 ILCS 705 and then 15, which of course, the 15, that's the dispo section. And then 175A, that points you back to what Dan mentioned, the Administrative Review Act. So we still don't know when that 35 days is going to start, but it could be any day now. Oop, hit my mic, my bad. Yes, and then Dan wanted you to take this slide because it's true. Like you mentioned this already, you can't sue for no cause. You need to have a cause.
Right, and for those of you who are trying to keep track of the calendars, as Tom just said, we don't know the final date yet, but you might want to just look at towards the beginning of October, just for as a placeholder for now, to make sure that we don't miss that 35 date. Now, several different things that we need to remember when we file a lawsuit. What are we suing for? Is it because the score was inaccurate? Is it because there's due process or equal protection claims? Is it because there was a typo? Is it because you submitted the same exact application in one region and got a 240 and in another region got a 220? Same exact application, so there's a disparate or difference of treatments between the regions. So we have to identify a reason. We can't tell the judge that we're just unhappy that we weren't selected as part of the lottery process.
Yeah, and that's that Rule 137. Now, if we're in federal court, it'd be Rule 11. You need to have some articulable basis in fact. You know, sometimes when more persnickety lawyers that were litigators would push that line, they would say, well, it could be true. And then I'm like, well, I'm not sure about that one there, sport. I think it's true because of, and then you have some type of suspicion and belief, but you need to have some type of facts that cause the basis for your lawsuit. And then there's a few, you know, maybe the lottery was rigged. Well, what evidence do you have of that? Go ahead, Dan.
Yeah, so 137 is the state law, Rule 11 is the federal law, and what that allows for is either a judge on his own or by petition from the opposing party to seek sanctions against someone who files a frivolous lawsuit, some lawsuit that really has no basis in fact. And those sanctions can be a dismissal of the lawsuit, it can be money, and or more. So no one wants that to happen.
No, you're gonna face a motion to dismiss anyway, and we're gonna talk about that later. And so knowing that you already have to face that, you don't also want to have to face a sanctions motion because you just sued because you felt hurt. For example, there's some other things that we have on here. Now, we're going to talk about what the administrative review law requires you to plead. There will be the word erroneous tossed around very often and also manifest weight of the evidence. But perhaps you were never provided with the appropriate 10-day notice of deficiency prior to disqualification. What you're trying to do is say the state was not following the law because insert your facts, okay? Scored my lottery application incorrectly, and therefore I was excluded from the lottery. Or let's say you got a 247 and somebody who won the lottery got a 215, and then you said, wait, the statute said that it was supposed to be to the top scoring applicants. I outscored him. How come they get a license and I don't? That's not top scoring. That's against the contrary drafting of the law. But all these types of theories can be explored and brought for purposes of what we would call erroneous scoring. Now, that's a little different than due process. So, Dan, why don't you tell the kids about due process?
Due process and equal protection is basically saying that you were treated differently, or the process of responding to the notice of deficiency, you didn't get a notice of deficiency, or you responded to it and it wasn't adequately dealt with, or that you were treated differently. So there are some claims that we see out there that certain groups, because of their minority status or because of their veteran status, they were treated differently by being excluded from the lottery or by inappropriately not receiving a conditional license. The other part of that is due process. Were you given enough information to be afforded due process? Some claims out there say, well, certain exhibits were voluntary, they were recommended, but they weren't required. But then when the state scored, they scored the application as if those exhibits were mandatory. That's a violation of due process. So those are usually claims that we see in federal court, claims that are constitutionally based, due process, violation of due process, or violation of the Equal Protection Clause.
And speaking of two in particular claims, and I have no idea why I'm getting that background loop, but good, it's passed. That's the new Lowy complaint that's out there in the federal court right now, the Northern District of Illinois, and they are bringing both of these two types of claims for pursuant to this particular federal law, 42 USC 1983. And then, they had the property right to have access to a fair process, a fair lottery, for example. And then with equal protection, that's also what he said. That's when it gets more into the discrimination of who was being discriminated against and for why. But those are. Let me ask Dan. We can also bring those in state court, right? Because this is a codification at a federal level, but we have the same type of amendment structure at the state court level, don't we?
Yes, that's right. And then what can happen is the state court might keep that and take it and run with it, or the state may then seek to push it into federal court and basically change that venue. And there are pros and cons with each venue. So a lot of times, if you think of state court, you think of perhaps a process that isn't quite as sophisticated or complicated. Federal courts, federal judges are very much into process, very much into rules, very much into keeping their docket moving quickly. Sometimes that helps, sometimes that hurts, depends on what side of the V you're on. If you're in state court, remember, we're filing a lawsuit against the state. So will that state court judge be inclined to rule in favor of the state because it's a state court judge? Sometimes yes, sometimes no. So we have to look at each case on its own merits, each case on its own facts, to look at whether federal court or state court venue is better.
Right. And with the way the I should just not stop talking because then eventually that echo goes away, or I should just say silence and then have it echo until it real-time webinars, folks. But one of the things that they have in the interplay between state and federal court jurisdiction is this thing called concurrent jurisdiction. So there might be some plaintiffs that are more suitable for the federal case and some plaintiffs that are more suitable for the state action. And even though they're interrelated, the courts sit in concurrent jurisdiction to one another. And you could bring that action in a state case, but then you could bring your federal civil rights actions under that 43-18 USC action that Lowy has brought in the Northern District, and then through supplementary jurisdiction, bring in the state court administrative review claim. But interestingly enough, that claim was not brought forth by Lowy's complaint. There was just two due process claims, no state court administrative review claim.
So there are a couple other ways to go too. All this is pretty high level stuff for those who are watching and may not be real familiar with the legal issues and strategies. But there are a couple other things that we can ask for before a judge, either at the state or at the local or at the federal level. One is called a declaratory action, and one is called an injunctive action. Mm-hmm. Okay. Declaratory action is where you're asking the court to declare as a matter of law that something was improper, to declare as a matter of law that the lottery process, as it pertained to you, as it applied to you, was wrong, or that it to declare as a matter of law that you should have received so many points on Exhibit D or K or whatever it is. Make a declaration. And the injunctive process is to enjoin, not enjoy, ENJOIN, to enjoin or to stop something from happening, to stop the selection of other dispensaries, to, in the Loewe case originally, was to stop the lottery. So there are other sorts of avenues that we can explore in addition to all the stuff that Tom had mentioned.
Now, can you compel? Oh my God. Okay, hang on. Now, can you actually compel a court action through the request for relief? Can you say, well, we don't necessarily want the injunction. The cat's already out of the barn on that one. We want to compel them to allow us to have more licenses that the state has.
Well, I think, Tom, there's a provision in the statute that allows for the state to issue licenses in outside of just the number of licenses they issued, whether it be the 75 or 55. And maybe you can speak to that. I believe that there is a remedy that we can cite to in the statute that says, and pursuant to this section of the statute, which you're very well versed in, that it allows for us to ask for that relief.
Excellent. All right. Well, the other thing I had was a little bit on the administrative review claims. And so when you're doing this action, you're looking for erroneous and contrary to the law. And so very often in the complaints that you may be reading that are out there that are on file and circulating, you'll say they'll very often make factual allegations that this state screwed up some particular thing, usually pertaining to their respective score, denying them points. So, the Cannabis Regulation and Tax Act is the law that they are trying to uphold and say you can't go contrary to this. And the law said it was top scoring applicants, and the law contemplated a fair application process. Now, you don't necessarily attack your unconstitutional theories in the administrative review claims. You're just attacking that what there was erroneous and contrary to the law. You've brought your unconstitutional claims in a different cause of actions, a different count on your complaint. And one of the reasons why is because the administrative review is contrary to the manifest weight of the evidence. Dan, can you explain the level of evidentiary standard that the court is requiring for these administrative review claims?
The court's going to look at what was referred to as the administrative record, everything that was submitted, the application, the response, the scoring, et cetera. And we, as the plaintiff, had to tell and convince the court that based upon the evidence in the record, there was a error, a manifest weight of the evidence, an error which shows that we should have been in the lottery or should have had 252 points instead of 260 points. I'm sorry, 240 points. We have to show by the manifest weight of the evidence. In other words, that the evidence is greater than not. That there was an error. Not that just we disagreed with it, but because there was a manifest way of the evidence of showing of an error, that we deserve what we're going to be asking for, change in the score, a license to be included, to be provided, to be part of the next round, etc.
Right. And so that's one of the reasons why I think that the Loewe case has not necessarily included a lot of these administrative review claims, because the preponderance of the evidence standard is slightly different, because the manifest weight is you have to conclusively prove that falsehood, that wrong, and there can't be any reason, any justification for it for the state. So it is more along the lines of beyond a shadow of a doubt. As opposed to this preponderance of the evidence, which through a civil rights complaint, you may be able to prove at that level, which is substantially less than manifest weight. So it's like just a 51% chance.
Correct.
Right. Okay. And so getting into the statistical analysis aspect of these, the case, remember how we were talking about how you just can't sue because you need a cause. And so what facts could you allege that the lottery that happened on August 18th was rigged? Well, there's a thing called judicial notice, and the court's allowed to take judicial notice of widely held under mathematical proofs and facts. And so you'd be like, well, according to math, there is the specific multiplication rule. So what is the likelihood of something happening? Well, the likelihood of something happening is usually the probability of it For example, let's say you were in a licensed lottery in Chicagoland and there was 901 ping pong balls in it, and you bought 46 of the ping pong balls. So you bought 46 lottery tickets to the show. That would have been 19 out of 901. And so approximately a 5% chance. And one of the things that I did in preparing for this to say, like, okay, well, can my good faith basis be kind of like not necessarily DNA evidence, because DNA evidence is of course different, but usually when you would have DNA evidence, it would be like, no, based on this science, it's a 1 in 5 billion chance. And so, okay, can we do that with the results as they came out? Well, let's go over this particular slide here. And so there were 75 dispensaries and please do pull the winners and check my math on it, because I recall doing it, but I don't have that up with me. But then there was the WA group, which has now bowed out. And so it's now the Hay group, but they won 2 licenses. They had 1 ping pong ball out of 64 in Rockford. And therefore, if it was a completely randomized lottery, it would have been 1 out of 64. But they had 5 out of 901 in Chicago. So that is not a 1% chance. That would be a 1/2 of 1% chance, a 0.00549. So then the SMR, which of course, for those of you following along, is the statistical something or other. It's the specific multiplication rule. According to the specific multiplication rule, that is a 99.99133% chance against. Now that's just one instance of a 99.99, which means that you're in like a 1 in 10,000 occurrence. 1 in 10,000 times, if you run that lottery, that should happen. And then you go to GRI's group, which had 19 out of 901. They won 2. These were also some of the litigants. So you have 2 of the litigants that were there, which is interesting. And so their math is 19 over 901 times 2, because they were there twice. Now, this is where we can quibble on the math, and we could say, well, that is incorrect, because actually, if they were already chosen for the first one, then they would have had not a 19 out of 901, they would have had an 18 out of 900 chance of being selected again. So the math would be tinily different, but essentially the same. And so then that's another 99.9, but this one's just a 5.5. And then you go to Botavia, which had 3 wins in Chicago. They had 46 out of 901 ping pong balls, which is, I believe, the most that you could have stuffed into the Chicagoland BLS region. And that gave you a 5% chance, roughly a 0.05105% chance. And they won 3 times. And then so did Blounce and Moore with the exact same math. So that is 2 other 99.986 instances. So then if you take those and continue this SMR process through, what is the likelihood that GRI, WA, Botava, and Blounce and Moore would have won in such a way? A 1 in 5 billion chance, because that's that 99.9999947% chance. So the record on appeal that Dan was mentioning earlier, it needs to include everything that you want reviewed, including the records of the lottery. Now, in theory, if this is a lottery that's conducted by math and in nerds and stuff, they should have had the method that they used to randomly select the numbers, and somebody should be able to confirm that random selection of the numbers was working, because that's a little peculiar, when you're looking at it. That's one. I don't know if that would rise to a factual basis, but I think it can, so that would be one of the, you would attack the process in and of itself. And so if the lottery was in and of itself the thing that you were attacking, in theory, everybody could sue, in theory, if everybody's been wronged,
And we'll let the audience come to their own conclusions on the 1 in 5 billion chance that those ping pong balls for those applicants were chosen.
Mm-hmm. But the next thing, Dan, let's go through the timeline that litigation very often takes. And so can you steer us through the timeline? And this is whether it's in federal or state, and you can kind of provide a little nuance regarding the differences.
So bottom line is, litigation in Cook County and in federal court takes time. It takes patience. It takes resources, and all of you should be aware of that before you move forward. You file a lawsuit, and then it takes some time for that complaint to be served on the opposing party, and then after the opposing party is served, it takes some time for the opposing party to then file an answer or a response to the complaint. In this case, both Tom and I are assuming that the response will be a motion to dismiss. The motion to dismiss then takes a couple of months to work through. There's a response, there's a reply, there's a briefing schedule, there's a hearing date, and then the court will then consider arguments on the motion to dismiss. Sometimes an amended complaint is filed instead of a response to the motion to dismiss. And even if that is the case, then there could be a motion to dismiss on an amended complaint. All that we're calling motion practice, that we title under motion practice. Motion practice can take several months. It can take 2 to 6 months. After that time, then we go into what's called discovery. Discovery is the time when we have an opportunity to ask written questions, take called interrogatories, or ask questions during a deposition, as well as the other side. So it's all reciprocal. They ask questions of us verbally and on paper, that we ask questions of them, both verbally and on paper. And that discovery process can last another 6 to 12 months. Sometimes after that discovery process, you get into expert witnesses, which may or may not be applicable in any of these lawsuits. That can add another 6 months. And then there's just the time through the court system, because judges handle more than one case at a time, that all the other cases have to be resolved by trial or motions or settlement ahead of ours. So bottom line is, in state and federal, they can take years, 2 to 3 years. I would say federal court, you could probably chop off 25% of the time because it moves faster. But in state and federal court, it will take years to get through. All of you watching this just need to keep that in mind.
That's right. It takes time, but I'm okay now. And I'm assuming that's my competitors going like, hack him. He's in that ISP address. But whatever. And so at least the bandwidth's now good. The thing that I've seen, my record, and I should pull and see if this case is still pending. It was this terrible mechanics lien foreclosure mortgage Gordian knot litigation situation, which had been going on for 8-9 years, actually over a decade. But you can't do that in federal court. That was a state court action because of the way that this dockets are different. The federal court action is far more orchestrated. And so to the extent that there is evidence that the lottery was rigged, I'm not saying there is, I'm saying, well, that's interesting. According to this mathematical model, that says that's a 1 in 5 billion chance that this happened, but okay. And so now we should get into the aspects of what would you ask for when you are bringing this. That is your prayer for relief. And Dan was explaining various aspects of this in terms of declaration and in terms of injunction. But the prayer for relief is essentially a wherefore clause at the end of your complaint, where it's wherefore the plaintiff respectfully requests or prays for it, if you're praying man or person, that the following, the court order and enter something as follows. And so the court issue an order as follows, and then they go through A, B, C, D, E, F, G. And one of the things that I would put in mind on the prayer for relief would be my attorney's fees. I don't know if I'm going to be able to find the basis for them. Our civil rights actions can I recover attorney's fees and civil rights actions, Dan?
In 1983 actions, you can.
That might explain why you're filing there.
So that's another reason to consider filing in federal court. But before you file a lawsuit, you have to ask yourselves and us in consultation, what do I want? At the end of the day, what is it that I want? If I'm doing this just to feel good, don't waste your time and don't waste your money. Am I doing this because I want to get in the next lottery? I want a license. What is it that I want? Mm-hmm. And that's where we will then, at the very end of the complaint, after we talk about the allegations and we talk about the various causes of action that we just explained for a couple minutes, that's where the prayer of relief, as Tom just mentioned, that's where we say, this is what we want. And it's got to be recognized, something that the courts have the ability to give. We can't ask for, someone to resign or a public apology or something like that. We have.
I want a pony.
We can't ask for a pony. As much as we may want a pony, can't ask for a pony. What is it that the law recognizes that we can have and that we want? That's where the prayer of relief is.
Right. And that's also where it becomes a hot potato or a hot button issue, in the sense that, are you going to be asking for people's licenses that have already won them? Because that's where the litigation could turn into one of those Gordian knot, Golgothan things that just loom large. And we're going to actually be discussing a fairly large global settlement here shortly, because now that we're at the prayer of relief, that of course is the end of the lawsuit that you would be filing. And so I wanted to give a pitch to Cannabis Legalization News. This is our channel. Hopefully you're a subscriber. If not, consider subscribing, clicking that like button. You'll get a whole bunch of me explaining stuff in the cannabis industry. And that is a picture of a settlement agreement. And that settlement agreement came from a resolution of a whole mess of license holders in Nevada. And so that is the settlement agreement from the Nevada fiasco of 2018 that was entered into approximately a year ago in July of 2020. That is very often what the litigants are after. And it is a list of LLCs. There was a shuffling of licenses that went around. Now, again, the state said that there's 50 coming in after 2021 is over in 2022, which means that this is September 1st. You file the lawsuit, you're very quickly into 2022. In your request for relief, you can be like, I want some of those other licenses that are coming in the next lottery. And with that, I'm pretty sure we can actually start getting to questions now. There are over 20 people that are tuned in. A lot of them that didn't be able to catch it live will probably be emailing us questions as we go on. But what questions does the audience have? All right, there are a few that have come in. I'm not sure if Dan, you probably can't read them.
No, I can't. So maybe we can just
first
talk
time
about it.
that's okay. So one of them is by Nicolette Robinson. What if an applicant was excluded from a lottery that it qualified for?
Well, that's a great case to have. So, is it because why was that candidate excluded? Because they had 85% and they weren't part of the lottery system. Why were they excluded? So we first have to find that out. Mm-hmm. We understand that you're saying you were excluded, but why? And if there's a really good reason, if there's a reason with good faith basis, then we say, wait a minute, we were denied due process, we were denied equal protection, we were denied all these other things because we were excluded. So then the next question is, okay, you got into the lottery, but what makes you think you would have gotten a license from the lottery? And we have to say, well, we know that we wouldn't have got a license by being excluded from the lottery. We should have been included just like everyone else who was properly qualified.
Right. And so that may form a basis for an echo. And I almost want to drop out and come back in and see if that fixes it. But that could form a basis for your ability to request an additional lottery to be held. And then an additional lottery to be held with particular safeguards regarding random assurances. So Where is the receipt of this lottery? How was this program orchestrated? How random was it? Because it seems like it's a little off, but that might be stuff you find in discovery. And so if you think that the 1 in 5 billion, odds may yield some incentive for the state to say, hang on a second, let's talk about this here.
And if we can explain enough facts, then someone who's reading it from the state will be like, oh shit, wow, they had a 230, that's above the 85% threshold, they should have been in the lottery. Can someone explain here why they weren't? And ultimately, we would bring that before the judge.
Yep. And then next example, I could put the questions up, which is nice, and we'll kind of go through them.
Right.
We have a perfect score application -5 for the military. We therefore excluded from the last licensure for 75. Do we have a case under constitutional rights? And
That's
so
why.
that is the WA case. And that is, yes. Now, is that a suit that you could file? Yes. But that would not be an administrative review claim. Like they scored your application wrong. That is a constitutional claim. So you would say, I've been denied due process, or actually it's usually there's a special legislation clause that arose from the 14th Amendment's preservation of equal protection. And as a result, that's how you would phrase that. And that's what WA, and which I believe now we have to start calling Hay, was pled as.
So for those of you who may not be familiar, I'm looking at the lawsuit right here. This is the most recent complaint in the WA, W-A-H group, and Hay, H-A-A-Y-Y-Y, filed against the Illinois Department of Financial Regulation and the deputy director. And that lawsuit was very similar to the person who just asked this question. Mm-hmm. That lawsuit was voluntarily dismissed. It was never ruled on the merits. It was voluntarily dismissed because WA got a license. Again, imagine that.
1 out of 10,000, only in America. Ray asks, WA was allowed in the perfect score lottery and won 2 licenses without having veterans points. Is this a matter of due process? We had a higher scores than them. Now, if this can be confirmed, then that could be a good faith basis for that last lottery being conducted improperly. Now, and then you would say, well, am I going to set it aside? Am I going to say that the court should enjoin the issuance of those licenses, or am I going to ask for my own and be like, hey, I was excluded and it was rigged. That being the case, how about I get a license?
And just for those of you who are familiar with the WA case, was filed in state court, but did allege due process and equal protection violations.
Now we can move to, and again, Nicolette Robinson. How can an applicant be excluded from the first lottery but not the second lottery if there is social equity and they scored over 85% of the points? Because this was another one of the cases. This might be case number 2 for equal protection under the new Lowy case in federal court, where he claimed that was illegal discrimination in violation of the 14th Amendment and the protection for equal protection. So when they had the one segment of social equity, and then they had the social equity justice involved, and then they cut out the 10 full-time employees. There's an allegation now that violated their equal protection rights and was discrimination against a protected class on the basis of those things, which that gets into a different level of evidentiary and strict scrutiny and a whole other ball of weed, just like a kettle of fish or like a can of worms, just something really, really complex that a judge is going to look at and go like, when is lunch? Yeah. Can this be a class action to save on costs? Will it be expensive for everyone to sue individually? Well, it will not be any more expensive than standing up a cannabis dispensary in a highly regulated state like Illinois, which is approximately a $1.5 million lift before you have to sue. Now, if you want to try to save on costs for the class action, that may or may not happen. It might be advantageous, and that might be where this goes, because very often these constitutional rights, they last for 4 years. So you were just wronged by the last date of that administrative decision, which is still in the future. And then from that date, you'd have your 4 years to bring your constitutional claim. So if you give notice to this particular class of people, those 900 some teams or something that made the last lottery, or whatever the data set says, these are the excluded ones, you provide them notice, and then they can become a member of a class or not. But I can only settle for 10 licenses, and then that might be maxed out, guys. But that's one of the things. the class action makes it more difficult because, like, how many licenses are you really going to be able to get out of the state, right?
Let me just add on to that, just if I could.
Go for it.
Class actions are expensive and exactly to your point, Tom, but there are certain circumstances where more than one plaintiff, like we see here in Wah and Hay, can be named in a lawsuit. So if the factual circumstances are really the same, you can put 2 or 3 plaintiffs on a lawsuit, same complaint. There's some cost sharing, some cost benefit that allows you to do that. So obviously, if you have 2 or 3 people, different plaintiffs can share the cost by half or 30% or whatever the case may be.
Yes, there's ways that we're going to set it up, but we want to make sure that the retainer is enough to be able to make it through that first 150-ish day window of the fully briefing and pleading, motion to dismiss, and then after that, that's when real negotiations would start, because I'm pretty sure they're going to be like, pound sand, we got you, whatever, you don't know what you're talking about, until after their motion to dismiss is dispositive, which means they didn't win. And lawyers like to win so much that they invent words like dispositive to make up for like them saying that they had to lose. But Vebel 10 said, we were scored incorrectly and lost points for Illinois resident exhibit. Obviously, we should have had that point. Well, I'm not sure what your exhibit looked like. I can't say whether or not it was obvious, but provided that your exhibit tendered to the state the documentation that it specifically requested, yes, you should have had the points. But I don't know. I mean, like, that was the most frustrating thing of a lot of this procedure was I'd have to explain to clients why the application was getting different scores in different locations. And I'm like, I don't know, magic. And then Anna asks, same as above, should groups that have the same issue clump together, or can groups apply that may not have the same situation? It's good if they join together, because more leverage, more news, more press.
Absolutely. And they do have to have similar facts.
Right.
We really can't put more than one person on a complaint if their facts are different. Not only is it not appropriate, but the facts could be conflicting. So what we could be advocating for one client, one plaintiff in the lawsuit may not be to the best interest of the second person who was on that same lawsuit. So we want to have, going to name more than one, those facts have to be really very similar to have more than one plaintiff.
Elevator. Talk about the 5 building chance. How does that map out for Denigan, who was involved in the application process, then rendered her tendered her resignation, and started a consulting company that has direct ties to 21 applicants who received a perfect score? If you are given the rules to the game and then you change the game and then you tell somebody else what the rules are, I'm shocked that they all got perfect scores. I don't know if that is actionable. Could it be evidence? Could it be something like you would allege? Could that be an allegation of impropriety to give rise to your reasonable suspicion belief that the lottery was rigged? Let's see. I don't know. Is that something that you can also ask? And in your prayer for relief, does the court have the ability to reissue your application into another round? You can ask for it. Whether or not you can get it is another matter. But of course, try to only ask for the things that you think you're actually going to get. Don't ask for the moon and the stars. All right. Has this worked in other states where they sue? Yeah. That's why one of the things that I have in my possession, and so one of the deals that I'd be doing after the litigations are on file, and it survives the motion for summary judgment, is I'll take the settlement agreement from Nevada and dust it off and kind of read it and be like, all right, well, change the word Nevada to Illinois, and then change all these LLCs to our plaintiffs, and then we would start negotiations. But yes, was what the answer was to that. And then in further yes, there is the terrible case of Trueleaf, which sued in Georgia like before the application was due to get extra time to submit their application. And then do you know who came in first? They did. They came in first. And so sometimes you can start the lawsuit before the application. Well, I do want to thank everybody who did tune in. And I also wanted to thank Dan Shapiro for agreeing to help on this presentation of, crap you lost, and now what can you do? The next thing that you can absolutely do, and we would encourage you to do it, I will be sharing, and I already have. And then if you signed up, you will get this type form that I just put out right there. It'll take you to this. Okay, that's more than I wanted to share. I wanted to only share my screen, but then if I hit that, then okay, now it'll work. And so this is where it'll take you. Was your score wrongly decided? And then please fill that out. It says that it only takes 1 minute, and if you do that, then we'll have you in our system, and we can reach out and say, well, your fact patterns are similar here. Do you prefer state? Do you prefer federal? We're on a limited time frame here. Have you seen this new update? And all of those things. But you guys do have time to have your day in court. It may be successful, and I wish you well.
Thanks, Tom, for having me, and good luck, everyone. If there are any questions, please let either one of us know.
Yes, and to take us out, what am I going to do? I am going to do just our new CLN intro, and then we'll see you tomorrow. We have a good show, so please tune in tomorrow's cannabis legalization news.